May I begin? Thank you. Good evening, members of the tribunal. As earlier introduced, I am second counsel for the claimant, Kaihari Winer Limited. I will speak for 12 minutes and respectfully reserve 1 minute for rebuttal. Members of the tribunal, the very reason for the agreement between the parties is commercial certainty. However, this is undermined by the respondent, who has continually sought to avoid fulfilling its obligations to the claimant. Consequently, the claimant participated in two sets of proceedings to protect its interests. Firstly, upon the respondent's refusal to deliver any bottles of the wine ordered, the claimant sought an interim injunction to prevent the respondent from contracting to sell the wine. Secondly, the claimant was forced to defend the respondent's application for a declaration of non-liability, which was brought despite the arbitration clause in the parties' agreement. The question before this tribunal is whether the claimant may be awarded the attorney's fees that it incurred in these sets of proceedings. I will separately address the fees incurred in the injunction proceedings and in the declaration proceedings. Turning then to the matter on the costs incurred in the injunction proceedings, members of the tribunal, the breach resulting in this claim for damages is not in contention between the parties at this stage of the proceedings, and for greater clarity, this breach is the refusal of the respondent to deliver any wine to the claimant, and this is contrary to Article 2 of the agreement found on page 9 of the record. In relation to this, the claimant has two submissions to make. Firstly, the costs incurred in obtaining the injunction are in principle claimable under Article 74 of the CISG. And secondly, the costs incurred satisfy the requirements of foreseeability and mitigation under Article 74. Members of the tribunal, turning then to my first submission.
Sorry, this issue of cost, isn't it best left to the court that granted the injunction? Why are we asked to address this issue?
Mr. Arbitrator, our position is that we are not claiming these costs which were incurred in prior proceedings are distinguishable from costs incurred in the present proceedings. And this distinction was in fact recognized in cases such as Zapata case in the US. Members of the tribunal, turning back then to...
Sorry, I don't get the distinction. What's this distinction then?
The distinction drawn is between costs incurred in prior proceedings, which are determined, in relation to which the allocation of costs in relation to this is determined under Article 74 of the CISG, and costs in the present proceedings, which fall to be determined by this tribunal under Article 37 of the Vienna Rules.
What does Article 37 of the Vienna Rules say?
Article 37 of the Vienna Rules provide that the tribunal may allocate costs of the present proceedings as it sees fit.
Okay, all right.
Turning back to my first submission, as earlier expounded upon by my co-counsel, Article 74 is very wide, and we submit that it should be interpreted to encompass losses incurred in the reasonable pursuit of legal rights. Members of the tribunal, this is supported by the underlying principle of Article 74, which is that of full compensation.
Sorry, I'm looking at Article 74 right now. And even if I accept that it's broad to the extent of recovering losses, including loss of profits. How should I construe Article 74 to include the claims for attorney's fees?
Mr. Arbitrator, is our position that as long as losses are those that result from a breach of the other party, then they are prima facie awardable under Article 74. Yes, Mr. Arbitrator, and this is stated by Professors Schwenzer and Slechtrim, and if I may quote, they state that these losses include incidental losses including, quote, those incurred in order to avoid any additional disadvantages. And Mr. Arbitrator, to illustrate, in the 2012 digest of CISG cases, examples of costs which are allowed under Article 74 include those for example, the sending of attorney's letters, because these are costs which are incurred in order to pursue legal rights.
Yes, but in the present proceedings, you're not asking or asked to award you something as simple as cost for documentation. You're asking us to award you costs for the proceedings in the national court, correct? The
Yes,
injunction
Mr. Arbitrator.
proceedings. Aren't those two different creatures in terms of legal costs?
Mr. Arbitrator, it's our position that there's no difference in relation to Article 74 between these two types of costs.
Okay, why?
The only difference that we see is that of res judicata, perhaps. And it's our submission that res judicata does not apply in this case because res judicata requires identity of issues. And there's no identity of issues in this case because our claim before this tribunal is under Article 74, but the costs under before the Mediterranean High Court would have been allocated under Mediterranean law.
Do you understand that?
Yeah.
Members of the tribunal, moving on to a more particular explanation of this, cases have also recognized that Article 74 encompasses a claim for cost of reasonable pursuit of one's legal rights. And this proposition has been affirmed in several cases, such as the Shoes case before the German Appellate Court, as well as a couple of CTEC cases, namely the nickel plating machine production line case and the chrome plating production line case. And the common thread running through all of these cases is that if an aggrieved party incurs costs prior to litigation to compel or ensure the breaching party's performance, then the innocent party is entitled to be reimbursed for the costs as part of its damages for the breach. Members of the tribunal, at this point we do acknowledge that certain cases and commentaries, such as the CISG Advisory Council's sixth opinion, have suggested that attorneys' litigation fees should not be awardable in a general sense. However, it's our position that these are distinguishable because those were in particular talking about the costs in current proceedings and not those of prior proceedings.
It is my understanding that the reason why costs weren't awarded when you filed an injunction, correct me if I'm wrong, is because parties were ordered to pay their own costs. Is that correct? Or is that
Yes, Mr. Arbitrator, that is correct.
So if that is the procedural law in which the injunction that govern the application of the injunction, what jurisdiction does this tribunal have to override that determination?
Mr. Arbitrator, the reason that we say that this tribunal has the power to award the costs that were incurred in that litigation is because the basis of determination are completely separate, and it's our position that this tribunal is in no way overturning the cost determination in that court. Turning then to the facts of the present case, the injunctions sought by the claimant were in reasonable pursuit of its legal rights in light of the manner in which the respondent breached its legal obligations. If I may point this tribunal to page 15 of the record, this is a letter from the respondent to the claimant subsequent to the claimant's order of wine. The last paragraph reads, and if I may quote, "There will be no delivery of any bottle of the 2014 harvest to you, even we have to drink them ourselves." Now, subsequent to this clear refusal by the respondent, the injunction was meant to protect the interest of the claimant. This was especially since the claimant had already accepted and was continuing to receive orders for the respondent's wine, which it had done on the basis of its agreement with the respondent. Furthermore, this should be seen in light of the bad harvest in 2014, which the respondent itself confirms at paragraph 1 of its answer to the statement of claim, which can be found at page 24 of the record. This is found at the first paragraph at the fourth line. Hence, it is our position that the supply of Mata Weltin in 2014 would be scarce. And this is especially worrying considering the claimant sells the wine in the collector's market, where reliability of supply is especially crucial, as stated at page 58 of the record, at paragraph 35. Members of the tribunal, we accept that the respondent may assert that this injunction was unnecessary at that point in time because it had not yet bottled the wine. However, this does not address the claimant's reason for obtaining the injunction. If this tribunal could turn with me to page 16 of the record. The second paragraph states that it would prevent the respondent from selling or committing for sale any number of bottles of wine that would prevent it from supplying 10,000 bottles to the plaintiff. Hence, the purpose of the injunction was not to ensure the delivery of the bottles per se, but to prevent the respondent from contracting out these 10,000 bottles of wine. Members of the tribunal, I see that my time is quickly running out. Turning then to the second submission in relation to this, it is our position that the cost incurred was foreseeable and the claimant had sufficiently mitigated its loss. Preliminarily, foreseeability is assessed when the contract is concluded and from the position of a reasonable person in the shoes of the respondent. In relation to this, the loss here was foreseeable because at the time of the contract, the respondent was aware that the claimant would be reselling the bottles of wine purchased to the collector's market, and therefore reliability of supply was crucial. Furthermore, the contingency fee itself was foreseeable because the respondent itself was familiar with these types of contingency fees as stated at page 59 of the record. Members of the tribunal, I see my time is quickly running out. I will quickly wrap up my the second point on the declaratory proceedings. Members of the tribunal, in relation to this, the respondent had breached the obligation to arbitrate under Article 20 of the agreement, and this is by initiating proceedings before the Mediterranean High Courts, as shown at page 17 of the record, where it sought a declaration of non-liability on the merits. As earlier stated, these damages should be caught under the broad umbrella of Article 74. In particular, in this case, the costs incurred satisfy the requirements of foreseeability and mitigation. First, I see my time is up and I may have 30 seconds to wrap up. Thank you. In relation to foreseeability, here, as the respondent had initiated proceedings before the Mediterranean High Court, it must be taken to have foreseen that the claimant would appear to defend its rights and therefore incur costs. Furthermore, the silence by the claimant is in no way a waiver of its rights. If the tribunal has no further questions, this concludes my submissions.
Good evening, members of the tribunal. As earlier introduced, my name is Lee. Now, second counsel for the respondent, Mediterranean. I will be speaking for 2 minutes, and I will expect you reserve 1 minute for some rebuttal. I will be addressing the issue of whether the claimant will pay the attorney's fees it incurred first, in its application for an interim injunction in the Mediterranean High Court, and second, in its defense against the respondent's action for a declaration of non-liability as damages under Article 74. We say that such a claim cannot be based on Article 74, and even if in principle attorney's fees could be claimable under Article 74, the claimant's loss was neither foreseeable nor mitigated. The claimant has urged this tribunal to take a broad view of Article 74, and the claimant is essentially relying on the principle of full compensation. But to that, we say that the principle of full compensation is not absolute and cannot be applied in such a way that the principle of equality between contracting parties will be impinged upon. If attorney fees were allowable in principle under Article 74, then the principle of equality would be infringed upon. This is because successful claimants would, by reason of their success, be able to claim attorney's fees. However, successful respondents who successfully defend against a claim for breach of contract would not be able to claim for attorney's fees because a claim for damages is contingent on breach. In addition, the claimant has relied on various authorities, Chinese and German authorities, to the principle that Article 74 encompasses a claim for a cost of a reasonable pursuit of one's legal rights. But with respect, members of the tribunal, these authorities do not stand for that proposition and they can be distinguished in due course. The German authorities the claimant has cited were actually decided based on explicit references and applications of German practices and statutes. They justified their award of attorney's fees under Article 74 on the basis of the influence of national practice. And as for the Chinese cases decided by the CTAC, these cases were decided before the CISG Advisory Council Opinion Number 6, which was published in 2006. And what the claimant has failed to mention was that cases decided after 2006 did not award attorney's fees under Article 74, but awarded them under the CTAC arbitration rules instead. Therefore, these cases only reflect domestic approaches to the issue and cannot be used to inform the interpretation of Article 74.
Be that as it may, given the ambiguity in Article 74, why shouldn't this tribunal grant the claimants the interpretation that they are seeking?
Because there is an alternative interpretation, Mr. Arbitrator. That was the interpretation provided by Justice Posner in the Zapata Hermanos case. And that was a case which explicitly decided on Article 74 and said that attorney's fees cannot be awarded under Article 74.
Why?
Because such an award, as I have explained, would impinge on the principle of equality between contracting parties.
Is there another ground apart from infringing on the principle of equality?
Another principle that was mentioned was that Justice Posner said that because different jurisdictions have different rules governing costs. So the US, for instance, awards damages as they fall. So each party is to bear its own costs. And he mentioned that the US would not have signed the CISG if it had known that this Article 74 would be such a broad umbrella that all claims, including claims for attorney's fees, would be awarded under this head. And another reason for this is provided by Professor Alastair Mullis, who argues that different countries characterize cost differently. So in Finland, for instance, they take an all-encompassing definition of cost. So costs there include pre-trial collection expenses, negotiations, consultations with an attorney before summons have been served on the other party. But in Germany, for instance, costs only include the expenses incurred after the initiation of the proceedings in a court of law. So if this tribunal were to award attorney's fees under Article 74, this would risk disturbing the delicate political balance achieved at Vienna, in his words. And this is seeking to enforce a uniformity ex post facto that could never have been achieved at that time.
Okay.
In addition, the claimant argues that the only limitations to Article 74 are the limitations of foreseeability and mitigation. But we say that these barriers are insufficient. These are broad, lenient, and vague principles. And this court should not award attorney's fees under Article 74 on the basis that these are the only two limitations.
I understand your submissions, counsel, but in light of the facts of the situation, where the claimant's procedural fees and quite substantial if I may add, were refused to them by virtue of a set of laws that if we view to be unnecessarily restrictive or limited in its application, why shouldn't we be inclined to buck the trend and say that yes, we will award due costs, particularly since the breach is not disputed by respondents?
Mr. Arbitrator, that is because the Mediterranean High Courts have already adjudicated on this matter, and essentially what the claimant is seeking is to appeal the Mediterranean High Court's decision. It is seeking a second bite at the cherry because costs were not awarded in the Mediterranean High Courts.
As I understand it, counsel for claimant submission is that is a matter of procedural law that was settled by the Mediterranean courts, and that this court's jurisdiction to determine the issue of cost is not impinged because it's a separate basis for determination.
Indeed, Mr. Arbitrator, but we actually, our submission is that if the two factors that cause the attorney's fees, so the claimant has acknowledged that costs in the present proceedings will be awarded under Article 37 of the VIAC rules.
Yes.
But we say that the breach and the causation that was present in the injunction proceedings are just as present here. So if are just as present in the present proceedings, because the present proceedings are essentially the claimant's claim for damages, and this claim for damages was caused by the respondent's breach. So we do not see this distinction that the claimant is attempting to draw. And we are saying that what the claimant is essentially seeking to do is to appeal the Mediterranean High Court's decision. And there were, in fact, certain grounds on which it could have done so, on the grounds that for the application for the declaration of non-liability, that the respondent brought this declaration in bad faith, or that it was a frivolous application, but it did not choose to do so. And because it did not choose to do so, it cannot now come to this tribunal, recharacterize the claim, and seek for those costs as damages. Now, if I may move on to my arguments on the foreseeability of the injunction proceedings. The claimant has raised certain facts. For instance, Mr. Weilmauer's letter at page 15 of the record. But to that, we say that foreseeability is assessed not at the time of breach, but at the time of contract. And at the time of contract, the respondent could not have foreseen that the claimant would have gone to the Mediterranean High Courts to seek for an interim injunction. For three reasons. First, because there was an arbitration agreement in the framework agreement. And there was an arbitration clause, in the framework agreement. And the VIAC rules actually provide for interim measures such as injunctions under Article 33(1). So the claimant could have sought for an injunction before an arbitral tribunal in accordance with the arbitration clause. And this would have been consistent with industry practice, which is to settle disputes amicably and as a last resort in arbitration proceedings, instead of going to litigation.
Sure, but can you respond to counsel for claimant submission that the injunction was necessarily in line with peculiar circumstances? The fact that they had very special clients, reliability is a big issue, coupled with the bad harvest, that all those seem to be extenuating circumstances that justifies a recourse to the courts.
To that, Mr. Arbitrator, we say that there was actually no urgency in its application for an injunction. So if I may refer this tribunal to page 59 of the record, at paragraph 48. So we see here in the last, the fourth line from the bottom, that the injunction was actually granted in line with the minority view under Mediterranean law. But according to the majority view, the existing risk would not have met the threshold for granting interim relief, as the actual delivery of the bottles preventing fulfillment of the contract with the claimant was not imminent. So this actually affirms what we submit, that the risk was not high. And in fact, this can be seen in the claimant's subsequent actions after it was granted the injunction. So it applied for the injunction on 8th of December, it got it on the 12th of December, but it is only bringing proceedings before this present tribunal on the 11th of July. So it waited for 7 whole months before it decided to sue for breach of contract. And we say that there was no urgency at the time of breach. And therefore, the claimants, it could not have been foreseen by the respondent that the claimant would have gone to the Mediterranean High Court seeking for an injunction. Now, If I may continue with my arguments on the contingency fee arrangement, we say that the claimant is stopped from claiming for.
Is there a doctrine of estoppel?
There is a doctrine of estoppel under Article 80 of the CISG. And this is affirmed by the interpretation of Article 80 can be informed with the doctrine of equitable estoppel under Article 7.2 of the CISG as a rule of private international law. If this tribunal will refer with me to page 33 of the record. We see here a letter from the respondents to the claimants informing them in the third paragraph that if no settlement can be reached within the next 2 weeks, we will initiate proceedings applying for a declaration of non-liability. You will find the draft application attached. And in the paragraph after that, we inform them that the High Court in Capital City has already been selected by you for your application for interim relief, for the lifting of which we will also apply. And we are not saying that the claimant has to immediately respond to us, but it is actually stated in Procedural Order Number 2 that the claimant simply forgot to reply to this letter. What the claimant could have at least informed the respondent could be, for instance, put us on notice or informing us that its tentative views on the matter is that the arbitration clause is valid and that therefore we should not seek for a declaration of non-liability in the Mediterranean High Courts. But the claimant simply forgot to respond to the letter. And because of this, the respondent's submission is that the claimant is to stop from relying on the respondent's breach because of its own actions. If this tribunal has no further questions, this concludes my submission. Thank you. Thank you.
May I begin? Thank you. Members of the tribunal, the claimant has just one rebuttal to the respondent's submissions. We have heard from the respondent that the claimant could have obtained interim relief before this tribunal. However, this is simply untrue. Firstly, the claimant had to obtain relief within a month because the respondent starts contracting with other customers in January. This should be seen in light of the especially high demand for the 2014 vintage, which is the subject of this dispute, and furthermore, the short supply as admitted by the respondent. Secondly, under the VIAC rules, there are no emergency arbitrator provisions. And in fact, in this case, with the full cooperation of the parties, the tribunal was only constituted on 15th September after the submission of the claimant's claim on 11th of July, which is a time period of 2 months. Therefore, it is our position that it would have been too late to obtain the injunction to prevent further contracting, contrary to the respondent's position. And this concludes my rebuttal.
Members of the tribunal, in response to the claimant's rebuttal, the respondent submits that there was no urgency on the facts. As I have already pointed out, the claimant itself waited for 7 months before instituting the current proceedings. And in any case, the respondent bottles its wine in late April to May. And under the VIAC rules, the claimant could well have obtained an injunction, but it did not choose to do so and cannot now seek to claim its costs as damages. this concludes my rebuttal. Thank you. Thank you.